Welcome to Impact Makers Radio, featuring industry thought leaders sharing problem-solving insights to help grow your business and live the life you love. And here's your host, Stewart Andrew Alexander.
Hi, and welcome to another Let's Talk Bankruptcy conversation. And on this segment of the show, ladies and gentlemen, I have Bankruptcy Attorney John Bircher, Shareholder and Vice President of White and Allen, PA, calling in all the way from New Bern, North Carolina. Now, John, who is considered to be a leader in the area of bankruptcy, will be talking to you today about minimizing stress in the bankruptcy process and best practices for discharge and a fresh start. Now, that sounds like a very interesting topic. So, if you are one of the many debtors looking for competent counsel in the New Bern, North Carolina area, it might be a good idea just to take a break. Down tools, log out of Facebook, give Twitter a break for a few minutes, even grab a notepad and pen and get ready to take some notes as we listen in to what John has to share with us today. So, with that said, let's not keep him waiting any longer. Welcome to the show, John.
Well, thank you very much, Stuart. It's an honor and a privilege to be with you today.
And it's a privilege for us also, John. Thanks for taking the time out of your busy day to come and speak with our listeners. So, that said, John, let's just jump straight in. Can you, in your own words, just briefly describe the kinds of people who you serve and the various types of situations they find themselves in when they come to you for your help?
Well, thanks. I've been practicing since 1997 in the area of bankruptcy. In a lot of my early years of practice, I was involved with filing Chapter 7, 13, and 11, and some Chapter 12 cases for debtors. As my practice evolved, I started working more as a bankruptcy trustee after I was appointed to the panel roughly in 2005. And so, with the debtor background that I had, and then doing more trustee work now, I've seen several different ways that debtors approach their bankruptcy cases, and have also, been able to sort of make some observations for future clients about, the best way to get through the process. As you know, just from your podcast, that debtors are obviously in a very stressful position and don't really know what to do to even really get started, because bankruptcy is not something that comes up at at lunch at work with your cohorts. It's something that we end up sort of internalizing, which increases the stress levels, and then it also creates domestic discord when it's a family debt situation. And a lot of times, folks, it's their very last resort. So what that usually means is that a family member has loaned them money, or they've gone way over the edge with credit cards and things that will never, in their lifetime, be able to pay back. So, between that and then the general sense in America, and the general sense that if you file bankruptcy, you're somehow bad. All of those things working together really put a lot of pressure on, your emotional, and really that bleeds over into your daily life and can cause some real strife. So, what I like to try to do, even as trustee, is remind people at the creditors meetings that, this is a legal action. It's even mentioned in the Constitution that, the federal government will make laws pertaining to bankruptcy. So, I try to remind people that it is something that is okay. It's not something we prefer. It's not something anybody wants to do, but it's a vital part of our economic system to flush bad debt that's never going to get repaid. So, once you sort of overcome that aspect with a client, a potential debtor, they seem to relax, not completely, but enough to be able to process that this is something they need to do. And once they make that decision, Stewart, I can't tell you how many times I've had a client say the day that they filed their case, as soon as they heard it was filed and they got a case number, that just the weight of the world was off of their shoulder. So that's been a real benefit for me in my practice. You don't really know, obviously you get paid to do this, but for sort of an emotional aspect of practice is seeing that benefit, translate into some positivity for the debtors. So.
Okay, thanks for sharing that with us, John. So, obviously, it goes without saying that anything you share with us today, John, is not legal advice or legal assistance. It's just purely information. And I'm sure since you've been helping people since 1997 in the area of bankruptcy, that you've come across many misconceptions out there. People come to you with preconceived notions. They've read something on the internet, they've Googled it, or they've heard from friends, family, colleagues, and they come to you and they believe that what they have heard or read to be true. However, on the contrary, you know that it's not true, and you have to spend time dispelling those myths. Now, of all of those misconceptions, we obviously only have a certain amount of time, but I'm sure you could spend at least an hour, if not longer, just speaking about the common misconceptions out there. But of all of them that are out there, John, what's the most common one that you come across while you're out there working with those debtors who come to you looking for a more competent counsel?
That their credit report, everybody's very focused on credit reporting, and part of that is just what you say, the internet, and we get pounded every day with free credit report, dot this, free credit report, dot that, like it's the end all be all of a human's existence is to have a good credit score. And so what that translates in bankruptcy is the misconception that if you file bankruptcy, you're doomed for life with a terrible credit score, and you're never going to be able to utilize credit again. And so there is a very conscious effort on debtors' attorneys' parts, especially those that specialize in bankruptcy. I've been a specialist since 2009, and the level of competence in bankruptcy attorneys is crucial for debtors to make sure that they research the lawyer that they plan to go talk with and see that he or she is a specialist in bankruptcy, because especially when it comes to credit reporting, and getting back to your question, bankruptcy, if you obtain your discharge, flushes out all of the pre-petition dischargeable debt, and actually in some instances can actually improve your credit score, because what some people don't realize is that if they just have lingering debt issues and creditors are constantly reporting negativity, it's just going to make your credit report that much worse. There are certain aspects of the credit reporting that even I don't fully understand how they calculate, but I do know that a discharge actually sort of hits a reset button, especially for unsecured credit in credit cards and such. I've had a number of clients come back to me and say, I've gotten 3 pre-approved solicitations in the mail 6 months after my discharge. And part of that is because creditors know that if you're discharged, then you're pretty much wiped clean, and it's time a lot of debtors just can't help it. They go out and they apply for credit again, but they can't file another Chapter 7, say, for a period of time of 8 years from discharge to filing. So they know they've got debtors right where they want them. So I would say that the number one misconception that we have to approach is the credit reporting area.
Okay, so based on what you just shared with us, John, and obviously keeping your client's confidentiality in mind, share an example of how you've helped someone who came to you with those challenges you just described, that misconception, and What kind of transformational results you were able to gain for them?
Well, a lot of the credit reporting type issues are, post-discharge, post-representation from my involvement. But I can tell you that as a very general example, a lot of times, especially in a Chapter 7 liquidation discharge, clients will sometimes call in later and say, "Hey, I can't find a copy of my discharge, but I'm getting ready to buy a car, and as long as I have my discharge, they'll go ahead and loan me the money for the car." And that was in a situation where the individual had his car repossessed during the bankruptcy because he couldn't afford it, couldn't pay for it. But this time he was able to go out, show a track record since his discharge, and he was able to, I don't know if convince is the right word, but he was able to procure this loan, and it was a much more affordable vehicle, and he was able to sort of start building his credit portfolio back up in a way that's beneficial to our society as a whole. So he went from a no pay to a good pay, which will be beneficial for him in his future.
That's excellent. Thanks for sharing that with us, John. Now, just as a reminder, today's topic is minimizing stress in the bankruptcy process. And we're also talking about best practices for discharge and a fresh start. Now, with that in mind, John, and for those debtors looking for competent counsel, and they're out there wanting to know more, what's the most common but unknown pitfall that you'd like them to be aware of, no matter how they feel, no matter what kind of situation they find themselves in?
Well, the most common pitfall is going after and trying to hire the cheapest bankruptcy lawyer they can find. And some of that is, I'm broke. How am I going to go out and pay for a bankruptcy lawyer? Well, there are ways that you can handle that. And I won't go into too much detail about that because I don't think it's appropriate for me to do so. But what I can say is that, when you're out there looking on the internet or wherever you look, first thing you need to do is, it depends upon where you are in the United States, whatever district you're in. The first thing that I would do is check with the Bar Association of your state. And I would try to find out who handles the legal specialists section of that bar. And then I would ask for a list of the experts, the specialists that handle consumer and business bankruptcy cases. And then those list specific areas of your particular state or region or what have you. And then you start there. Do not start on the internet with $99 or bust bankruptcy law type ads, because those mills, as they are called sometimes, don't always spend the quality time and attention that debtors potentially need in a case, because a lot of times a lawyer, because we're under a lot of pressure to make sure that we pay our rent and make sure that we pay our employees. So one of our charges as lawyers is to ensure that we're providing the best legal service for our client and zealously representing them. And some of the pitfalls for a debtor is to number one, not getting competent counsel, but number two, once they do get competent counsel, not completely and thoroughly giving that counsel every single fact regarding your financial situation. Because if you leave things out, once you file and a trustee finds out about something that you've left out, it's fairly too late at that point.
Right. So you emphatically have to lay all your cards on the table, no matter what situation you find yourself in.
Absolutely.
Oh, fantastic. So, John, let me just ask you then, if somebody does go through that process, what you just recommended of getting that list, and they then have some options of what appears to be competent counsel, what would be one or two things that they would need to look for or even ask that competent counsel to determine whether to move forward with them or not?
Well, I mean, as I've said, and I don't want to sound like a broken record, but make sure that they are a certified specialist by the whatever state bar they're calling. Make sure that they have sufficient numbers of years of experience, and normally, if they are specialists, they will probably have published articles or have information about that particular lawyer other than in an advertisement. And so those are you can't put a price on making sure that your financial circumstances are handled in a competent manner.
Fantastic. Thanks for sharing that with us, John. So, John, on a more personal level, if you could just imagine for a moment that it's a Monday morning or any other morning of the week, and your alarm clock goes off at 6, 7 a.m., and you have a full day ahead of you helping those people, those debtors looking for competent counsel. After being so many years and handling so many cases, is this something that you're still motivated to do, John? How do you feel on a morning like that?
I think everybody has those moments where they wish they could be doing something else. But I can tell you that after 20 years of being involved in the bankruptcy system, I couldn't be happier with an area of practice. Bankruptcy touches just about every other area of the law, and it is I would say, a highly specialized area of the law, and it's always a pleasure to be able to help fellow counsel in other areas such as estates and estate planning and really even any kind of civil law, real estate, all of those things. I enjoy helping other colleagues that aren't involved in bankruptcy try to navigate that system a little bit. So that's for me it's a joy to be able to help folks and to also sort of guide the system as a trustee.
And as you're sharing that with me, I can just feel a smile coming across my face because I'm actually picking up on your genuine passion for what you do. So I'm so glad that you just opened up a little bit and shared that more personal side of what you do. So let's just stay in that vein then, John. Could you just share, just for a few moments, what led you to the field of bankruptcy and what you're doing now? And then also share a little bit about your education, especially your formal education and your experience as it relates to the topic of bankruptcy.
Well, sure. I can, let me sort of start with the second part of that, and that'll lead you through. I went to undergrad at the University of North Carolina at Chapel Hill, and I actually grew up on a dairy farm in eastern North Carolina. Went to North Carolina with the idea that I wanted to get into law because I was kind of tired of milking cows as a youngster and knew that that's not what my life was going to be about. My great uncle was a judge in the area where I lived, a very rural area, and I got to go to court with him, and I just loved that we have such a system of jurisprudence that allows anyone and everyone to have a fair shot at the court system. So then I went to Campbell University School of Law in Raleigh. At the time, it was not in Raleigh, but it's in Raleigh now. And that school really focused on representation of clients in the North Carolina area. And so there was a lot of practical skills and knowledge and learning how to deal with clients, other than just in the courtroom, because it all comes down to preparation. Everything sort of is won or lost before you get to the courtroom. So that was very encouraging to me to be able to go to a school like that. And then, to get into bankruptcy, I started with a firm here in New Bern. And I was actually started out doing family law and speeding tickets and general criminal practice. And after about 6 months, there was a big bankruptcy glut, and my firm was a bankruptcy specialist firm. And I flipped over and just fell in love with it and was glad to get out of domestic and criminal law.
Yeah, that's such a great story, and you seem to have just found your true north, because I can just really feel your passion coming through for what you do. So thanks for sharing that really interesting story with us. I'm sure there's just so much more that you could say, but we are limited by time, John. So thank you for that. So John, if you could just picture for a moment those debtors who are out there looking for competent counsel, and they come to you for a consultation and they're wanting to dig deeper into the topic of minimizing their stress in the bankruptcy process. And yeah, they want to know more about best practices for discharge and a fresh start. Now, with that picture in mind, John, what final thoughts would you like to share with them before we finish up with our last question for today?
Sure. One of the primary things I would say is that they don't need to second guess whether a fact is important to the attorney. In other words, a lot of times clients, we give them worksheets and they fill out and they answer questions on the worksheets, and then we sort of have this all-encompassing, is there anything else that you haven't listed that you own or that you have an interest in, or that you think you may have some sort of property interest in something. A lot of times you'll have clients later on, after a problem comes up, say, well, I thought about that, but I didn't really think it was that important. Well, the reason that you're seeing a professional is because you don't know what's important. So I tell people, always default to telling everything and let us deal with it, because if we don't know, we can't help you. And that's primarily the best way to reduce stress, is just to let it all out there, give us the full picture, and we can certainly focus and come up with a result.
I'd normally move on to our last question, John, but I just get a sense that this not sharing all the information is something that's really, really important. So could you just to briefly just share with our listeners just how important that is? I know you've already alluded to it already, but what kind of things could happen when they don't share everything?
Well, I can give you a great example. As a trustee, I was assigned a case where a gentleman filed bankruptcy, and he had been very successful in business, and he decided to leave out the fact that he had collected over 400 vintage guitars and attempted to hide those from me as trustee, saying that they were basically his retirement. We were able to find out about those. It's another great story at some point in life. But he lost his ability to get his discharge, and I actually was forced to refer his case to the U.S. Attorney, and he was prosecuted for bankruptcy fraud and spent some time in a federal prison because he thought that he knew better than his bankruptcy lawyer about what should and should not be revealed. If he had revealed it initially, he may have been able to keep some of them under his exemptions or his other potential processes through the bankruptcy system. But since he tried to skirt the system bit him pretty hard.
So what's the motivating fear behind people holding back information then, John?
Well, I think primarily it's they don't want to lose something, a vintage car that the grandfather had given the debtor, and it never was titled, so, there's no way for us to really know unless the debtor tells us about it, or usually a disgruntled family member who isn't getting repaid for some reason usually gives us a call and says, hey, you may want to check out, his garage. The truth will set you free in the bankruptcy process, so put it that way.
Right. Well, ladies and gentlemen, I hope we've made that point very clear. It seems to be something that's really, really important. If you are working with a professional like John, just be open. Share everything. That seems to be the way to go. So, John, finally, if there is somebody out there who is wanting to know more about minimizing stress in the bankruptcy process, where would they reach you? How would they be able to find you, John?
The easiest way to do it is to probably go on our website. It's www.whiteandallen.com. And you spell out the and it's ALLEN.com. And we are in New Bern, North Carolina. We have offices in Kinston, Greenville, and Snow Hill, North Carolina.
Fantastic. Is there also a number, a central number they can call?
Sure. Absolutely. 252-638-5792.
Fantastic. Okay, ladies and gentlemen, so that was it for today. So whether you're out there and you're listening in your car or you're tuning in at work, hey, you shouldn't be doing that, but hey, we don't really mind. Or maybe you're out taking a run and you're listening in on your personal headset. We do, unfortunately, have to part our ways just for today. However, that was bankruptcy attorney John Bircher. Thank you so much for sharing so generously with us today, John. You have certainly, without a doubt, demonstrated that you are a true educator and advocate for your client success. So thank you so much.
Thank you for the opportunity, Stewart.
You're so welcome, John. And I'd also like to say a big thank you to you, the listener. Thank you for joining us on this, what I can only describe as a very insightful and informative discussion with one of the top bankruptcy attorneys in the New Bern, North Carolina area today. Again, that was John Bircher. Remember his name. Make sure you do check him out. Give him a call, drop him an email, find all his contact details on his website. Whatever you do, I'm sure you're going to be in a great place to get started. So that's it, folks. Again, my name is Stewart Andrew Alexander, and we'll be back shortly with some more leading bankruptcy professionals in this, our series of Let's Talk Bankruptcy Conversations. So, until then, take care, have a great day, and we'll talk real soon.
Thank you for tuning in to Impact Makers Radio. To listen to all past, present and future industry thought leaders and trendsetters, visit us at impactmakersradio.com.